A common question we often receive is that for a foreigner to incorporate a Singapore company, why does he or she need a local resident director? The requirement as stated in Section 145 subsection 1 of the Companies Act is that there needs to be at least one ordinarily resident director in Singapore. This means that at least one director of the company needs to be residing in Singapore. This individual does not have to be a Singaporean or a Singapore PR. Instead, this individual can be of any nationality ordinarily residing in Singapore. For a foreigner to be a resident director of a Singapore-registered company, he or she will need a valid work pass. An example of a valid work pass would be the employment pass, which is issued by the Ministry of Manpower. For clarity, a Singaporean who is not residing in Singapore, for example, if he has migrated to and is living in Australia, will not fulfill the requirement in Section 145 subsection 1 of the Companies Act. This is because he is not ordinarily residing in Singapore. The key consideration is the ordinary residence of the director. The company can have multiple directors. However, at least one of them needs to be ordinarily residing in Singapore. In cases where this requirement cannot be met, then the company may appoint a nominee director who is a resident in Singapore.